sir.
Mr. Vega, you remain under oath from when you were previously sworn.
Let's watch that. Your Honor, we would tender.
Okay,
All jurors, all jurors.
very good. Do we need, I think there is an exhibit that's still in dispute, correct?
Yes.
75, and remind me again which,
C3.
C3. Is that the only one, 3 and 10?
Judge, yes, it is, 3 and 10.
Okay, so can someone show me again 75C3?
Yes, Judge, I have both of them.
We might turn up the lights now.
Need the lights up there?
Might as well.
I'll work on it after.
Okay, sure.
Put it in.
Okay, so tell me, what am I looking at here?
Your Honor.
Yes.
No, they're not. Sorry, Your Honor, I have to say this one, but they can
Okay,
Sure.
what is this?
The messages, which are to what appears to be an iCloud, Your Honor, are iMessages back and forth with this defendant and a 6-block member, so a member of the opposing side of her current boyfriend from back in 2020. That 6-block member is explaining to her some of the issues that he is having with Charles Jones. These are the messages during which or in which the defendant specifically talks about the witness, Mr. Howard specifically talks about his involvement in his activity that's occurring in Jacksonville, and about the death of Bibby, another source of what we expect some of the testimony to be. These messages with this individual also discuss J. Ja'Cory Rivers is the true name of Mr. J. And he is associated in this case in that he funded or sent the money for the Airbnb to the defendant's boyfriend, Mr. Chance, in advance of his using his Airbnb or his Cash App account to book the room with Mr. Murphy. So that's why we are seeking to admit these, number one, for the defendant's knowledge of, again, this ongoing issue between the two groups, but additionally the link to the other individuals associated to this case.
Okay, so where it says, who is kshorty335@icloud.com?
His street name is K. Shorty. His real government name is Therese Powell.
Therese Powell. Okay, and so when I'm looking at this, for example, the first line says, you don't even sleep that hard, so you gotta be OTP. Who's sending and who's receiving?
The email that's above those messages on the left side are from K. Shorty's account. So that's the email associated essentially with, for example, iMessage, right? So those would be from him.
Okay.
And if you look to the other side, how it looks like it's tabs, that would be from the defendant in response to him.
Okay, so then, for example, the response to that, and you're telling me this is from the defendant, okay, I get that. I wasn't saying you can't post her. I just feel like you're not ready to talk to nobody. That's all. That would be from Ms. Andrews.
Correct. This is an extraction from Ms. Andrews' device.
Okay, okay. And so there's some then, so I guess just preliminarily looking at this, there appears to be a lot of extraneous conversation about a lot of other stuff that may not be relevant to this trial. That's kind of my initial first thought at looking at this.
If the court looks to looking at the 10/4/2020 message, that is the message in which I'm specifically referencing the defendant speaking about the case shorty, messaging to the defendant specifically about the witness that we were discussing earlier, Mr. Howard, and Bibby, the person that was with Mr. Howard during the murder of Spaz, or the person that was referenced yesterday, also the co-defendant's younger brother and cousin.
Okay, and this would be the message, you said 1020, which from case shorty begins, all I want you to do is protect me and make sure nothing happened to me because I'm gone. Do the same. Don't let nobody know we talked that you think gone, get around to somebody else because you never know what other people. Anyway, it's a very long run-on sentence. So is that?
Yes, it's a very long run-on paragraph. It actually starts at the 11:36 message from that same date, Your Honor. So on 10/4 of 2020 at 11:36 a.m., there's a very long run-on. It's just not able to be captured on the same page.
Okay, and so defense, what's your objection?
Several, Judge. I'll start with first just the date of the messages. They are even earlier than the messages that we objected to on yesterday. These messages are from October of 2020. The second issue is knowledge, Ms. Andrews' knowledge of what is happening in the city, connected to people, some of them that she knows, some of them that she doesn't know. None of them that she has a specific personal relationship with, is not a material issue in this case. It is a collateral issue. Whether or not she knows what's happening, every witness that's come up here has some idea about what's happening. It's not a material issue. The issue is whether or not she had the intent, whether or not she agreed to be involved in this conspiracy for a specific murder. There's no discussion about this murder that would happen 40 years later, or any intent of hers to be involved in it. It's completely not relevant. Also, the way the state characterizes these messages is very different than what it actually is. This is a man, a young guy at this point, and a young woman having a conversation about whether or not they're going to be in a relationship. This gentleman seems to be possibly suffering maybe from PTSD, or I don't even know what the messages are. It's just very long. Him talking about somebody accusing him of something that he didn't do, and pouring his heart out, hoping that he can live a normal life. He adamantly even denies being a part of it, so he's not an admitted member of any gang. And I haven't heard any testimony from any officer that he's a part of a gang, and I don't expect to, because it's not a relevant matter to this specific case. This is another attempt to, quite frankly, reach and stretch the idea that she is somehow involved in this particular murder because 40 years ago she had a conversation with a guy who was romantically interested in her, who was really talking about wanting to live a normal life and be away from all of this, and how he's warning people to stay away from it. So it's not even it is not actually the way that they're framing it. But even if it were, the fact that she knows these people, she lives in Jacksonville, Your Honor. She is from Jacksonville. It is inevitable that she's going to know people or have communication with these people. Her association, and I don't mean association literally with the gang, I mean knowing these people or coming into contact with them, is not a material issue in this case. It is another attempt by the state to put this before the jury to make it appear as though she is associated with the gang, when their own expert officers, detectives, are going to testify that she's not associated with the gang. It's really just an attempt to sour the jury, to inflame their passions, and to make it appear as though she spent her entire life being, cozying up to gang members. It's not relevant at all to what this case is about, and Your Honor has already limited the scope of what they're allowed to discuss outside of the actual murder. It's supposed to be limited to this 2023 shooting, and here we are again attempting to elicit, this person is not going to testify. I mean, there's a hearsay issue as well. But this is just not relevant information. It's confusing to the jury. It's not relevant to what they need to decide. And I don't see any probative value to any issue in this case. Her messages back to him are not discussing, it's not even connected to what she discussed, to what was discussed yesterday in the text messages. She's talking about not being romantically involved or being romantically involved with this guy. Him being a good person, her being a good person. This is not relevant at all to what we have. It's just an attempt to paint her, as a bad person who likes to be around gang members. It has nothing to do with the actual allegations in this case.
Okay, so again, I view this as direct evidence, not collateral evidence, and I did limit the collateral evidence as you indicated, but her statements, or her knowledge of the gang involvement and Julio Foolio and then the beef between the gangs is relevant to the case. But my biggest issue with this, these are just really long, run-on, nonsensical there's parts of it in here, for example, where there's talk about Julio Foolio specifically. Again, the second page of this exhibit.
Your Honor, I'd be happy to work with the exhibit and highlight more relevant portions, provide an updated copy of that to the defense. My only concern was the defense wanting the evidence surrounding those statements, but in the event that a more redacted version where it's just specifically talking about the parties related to this case and the individuals that were actually present with the decedent, I am happy to do that.
And Your Honor, if I can add, first, if the court is going to ultimately allow the man, I would like the opportunity to parse through, what we would.
Sure.
But
so,
also, Your Honor, based on the information that they introduced yesterday, the state has already established that she is knowledge. And it goes back to my point. What is the actual purpose of this outside of attempting to paint her in a particular manner? And I don't believe it's relevant. I understand the court's ruling, but outside of it already being established, it becomes cumulative. It becomes confusing. These are more names of people that are not involved in this particular incident. And additionally, Your Honor, it's prejudicial. It's significantly prejudicial. And I will also add this. If knowledge of the gangs, because the way that the state is painting it is though she has some kind of specialized knowledge of these, these incidents and these people, I don't expect objections when we question their witnesses about how common this information is, right? When we question them about the comments on, social media, the things that people seem to be aware of, the people that make videos and appear to have intimate knowledge about what's going on. If knowledge is, if they're painting her to have some sort of specialized knowledge, then I don't expect there to be any sort of objections or limiting to us establishing this is actually not specialized knowledge. This is information that anybody in proximity or with a phone could get access to because everyone is talking about it everywhere.
okay, well that sounds like your cross or closing argument, right?
Maybe both.
Okay. Okay, so you do need, I want you, State, to attempt to redact this just to, like pertinent parts, like I can make out in here, for example, the conversation, because there is an actual, start talking about Julio Foolio and 6 Block and ATK and who's involved and who's not involved, and so that kind of thing is going to be more relevant than a lot of this other stuff that's almost, to me, indecipherable.
Yes, Your Honor.
So anyway, so try and pare it down, run it by the defense, and then see if you guys, I know you don't agree to this coming in, but just take a look at their redactions, and if you are going to argue for further redactions, or if you want stuff left in for the rule of completeness, then let them know as well. So I'd rather have them start being conservative with their redactions and go from there, okay? And then,
And Your Honor, just to sort of add, again, there were 370,000 artifacts on this iPod device. I don't know if, the court, I don't know if it's something we need to address now, But I don't want this to continue to be an issue where we're continuing, every time that Julio Foolio's name is mentioned, that it's gonna be admitted, because my client, was in a conversation about it.
Well, they've only, let me put it this way. So as far as the exhibits for the state's case in chief, they've identified 75C3 and 75C10. So that's what we're discussing. So I don't know if the defendant testifies, if there's going to be something else that they're going to want to use to impeach her. I have no idea, but we're just talking about state's case in chief.
Correct, and that's exactly what I'm talking about. Right?
Okay, well, as far as I know, this is the only exhibits that they've produced to you that you're objecting to, not the only exhibits, but the two we're discussing.
Yes.
Okay, so then what is, so I'm going to overrule the objection to 75C3, but with the caveat, I want the state attempt to redact this to the truly pertinent portions of the message exchange.
And for the record, because I don't believe I said this, we also would object on the basis of hearsay.
Okay,
As it's related to the other person's
right.
statements, and based on what the state is saying, it appears as though they are attempting to elicit this for the truth of the matter, that she was aware of what was actually occurring, and that what he's saying is actually true. So we object on that basis as well.
Well, I think they're attempting just to show what her knowledge is, not that any of this is factually accurate per se. It's certainly not grammatically accurate, I can tell you that. Okay, so 75C10, what am I looking at?
Your Honor, 75.
These are messages from 2023,
Do you want to see? Sure.
or
Is it maybe C1?
it's marked as C10.
It's C10. We already just,
Oh, yes, that's correct. It's
the
just
only
for
other
another
one we did
number.
was C2, which was yesterday, and the other one was C10.
Yes, the exhibit list lists the defendant's number and can also include the co-defendant's number, but the messages for C10 are those between this defendant and her boyfriend, Isaiah Chance.
Okay, what's the objection?
Let me just confirm.
Do you want to see the exhibit?
Yes.
Sure.
What I have looks like it's C1.
Come on up.
Okay, now I'm looking at C1.
Okay. Sure.
Yeah, thank you. And I'll put both on the exhibit list just so it's clear for everyone.
I was locked out. Yeah, couldn't get back in.
We did that on purpose.
Here you go. Thank you.
Oh, okay. Is this it? Okay.
And I gave them a direct copy of the exhibit. So I was make sure that I respond to whatever what she says.
Okay. The clerk.
Oh, okay, I'm sorry. Yeah, she is that.
Okay. So,
Judge, we'd object for all the same reasons.
okay. And what's the relevance of this, Mrs.?
Your Honor, as it relates to the messages in C10, the communications between these two devices are both, again, the same basis, the knowledge, but specifically in the instance of the April 10th of 2023 messages, the defendant's co-defendant, Mr. Chance, is referencing 23. That person will be one of the individuals that was shot and killed at the town center that was referenced and will be ultimately referenced by our gang units as well in this case. it again goes to her knowledge of, not only her knowledge of those killings in the dispute, but the defendant's boyfriend, or Mr. Chance, the co-defendant, actually explaining to her what occurred there and why he will not return there, and essentially providing her with additional information about his problems with the other gang. Lastly, the first page, did you include this? I'm not sure. Does the court have that also? How many pages does the court have?
2.
By the inquirer? Okay, that's it. Those are the only ones now.
What's the TikTok hyperlink in here? What's that for? Do you know?
I do not. It would not reopen. The town center shooting that they're speaking about was a shooting in which 4 individuals were shot up, 3 of them died, 1 survived, that first music video was about. And again, that the When I See You music video by our victim was published regarding. Their photos are preserved in that music video. That was primarily what kicked off both sides.
Okay. I'll overrule the objection. All right, here you go. Okay.
Did I understand the defense to make an additional objection to 75C1?
I didn't hear it. I think when we first discussed this, we already discussed the 3 items. So on 75C1 is a text now chat dated June 17th of 2024.
Yes, and Your Honor, just to be clear, those are the 2 messages, the blue messages to,
Does the court have a copy of that?
I don't.
it's the 1 page, just 1 paragraph. Okay, yes, I don't have an objection to that.
Okay.
So, yeah.
There you go. Okay. Okay, anything else we need to discuss before we break for the day? All right, so it looks like, State, you might rest on Tuesday, maybe?
Judge, I know, possibly, I know that Detective Ramos's examination is going to be rather lengthy, and I anticipate his cross will be as well.
Okay.
And they're, so.
Okay. So you guys, whenever it is State rest, you all just need to be ready to go with if you've got any witnesses other than your client. Okay? So if you need Mr. Howard transported, you just need to make sure that you let me know so that way we can request him to be transported the day before.
But if they are going to conclude on Tuesday, which I don't know if that's...
Yeah,
We may go into Wednesday. I
That's
think
fine.
Ron Ramos is going to be pretty lengthy.
I guess I'm just trying to tell you guys, you need to be ready to roll into your case, assuming you're going to put one on. That's all I'm saying.
So, yes, I'm trying to figure out the logistics. So if they're going to end Tuesday, then we would want Robert Howard Wednesday. If they're going to end Wednesday, I guess depending on the time,
Yeah.
and we would want Robert Howard Wednesday still, but it's going to probably be Wednesday and Thursday.
All right. So it maybe sounds that most likely would be Wednesday for Mr. Howard. That's what I'm hearing. Okay.
I think so, because we saw the medical examiner, the ballistic expert, and some witnesses from Jacksonville.
Sure. Okay. All right, so maybe possibly closings Thursday? Okay.
Well,
Key. So we'll see. Okay. All right, very good. You guys enjoy your weekend too. All right. See you all Monday morning at 9 a.m.
So-